Hello. Welcome once again to What Nobody Told Me After 65. Well, it's your lady in the know, lady on the go, Miss Info. I'd like to welcome you to the Information Nation, where knowledge is shared and wisdom exchanged for the betterment of a people. Let's get started. This is the third part of the series on bankruptcy. I started with Chapter 7. I did Chapter 11, and I'm wrapping it up today with Chapter 13. Chapter 13, I'm going to spend a little more time on it because it's the one I filed. I'm more familiar with it, and I do believe it was the best one for me. It's a repayment plan, and that way you repay your debtors, and you know, for me, I saved face. I paid what I owed, and that made me feel better. Might be a little different for you, but again, do your homework. And by way of a disclaimer, I am not what? An attorney. I'm not an attorney. Okay? So here's an overview of Chapter 13 bankruptcy. People who earn a significant income or want to protect their valuable property will file for a Chapter 13 bankruptcy. In exchange for debt relief, these filers pay their discretionary income to creditors in a 3 to 5 year repayment plan. 3 to 5 years. You turn your money over and a trustee handles it. Okay? Eligibility for Chapter 13. For many debtors, Chapter 13 bankruptcy is a good option, but not everybody is eligible for a Chapter 13. And here's why. Any individual, even if self-employed or operating an unincorporated business, you're eligible for Chapter 13 as long as your combined total secured and unsecured debts are less than $2,750,000 as of the date of filing for bankruptcy. So when they say not everybody's eligible, if you're making over $3 million, this ain't for you. An individual cannot file under Chapter 13 or any other chapter if during the preceding 180 days a prior bankruptcy petition was dismissed due to the debtor's willful failure to appear before the court or to comply with orders of the court-appointed trustee, or it was voluntarily dismissed after creditors sought relief from the bankruptcy court to recover property for which they had liens. Creditors can stop you from being in a particular chapter filing. They can disagree. In addition, no individual may be a debtor under Chapter 13 or any other chapter of the Bankruptcy Code unless he or she has, within 180 days before filing, received credit counseling from an approved credit counseling agency. Okay? Either individually or in a group setting. There are exceptions in emergency situations or where the U.S. trustee for the bankruptcy court has determined that there are insufficient approved agencies to provide the required counseling. I guess if you live out in the boonies somewhere and you can't get an approved counseling, the bankruptcy trustee may say you can't do it because you have to have the counseling. Okay. What can you pay off in your Chapter 13 bankruptcy? What things can be included? How about I tell you things that can't be included? And then that way, that'll break this down. Here are the things that cannot be included in your Chapter 13. Alimony and child support. Certain unpaid taxes, such as tax liens. However, some federal, state, and local taxes may be eligible for discharge if they date back several years. I think the cutoff is 3 years. I think 3 years, I think it's 3 years. Debts for willful and malicious injury to another person or property. Willful and malicious means deliberate and without just cause. In Chapter 13 bankruptcy, this applies only to injury to people. So I guess if you were in a car accident and people got injured and you were found negligent, you were found responsible, you were the responsible party, then that's not dischargeable. Also, debts for death or personal injury caused by an intoxicated person. If you were drunk and drunk driving and that's what you were charged with, and ultimately you ended up having to pay, you have to pay that. That can't be discharged under Chapter 13. Now, any debts that you failed to list in your bankruptcy are not going to be discharged. So, let's see. You have, you forgot to include Fingerhut. Lord, those people. You forgot. I mean, it was a long time ago. Maybe you didn't, for whatever reason you forgot. And then you file and they don't get included. When you come out, you still owe them. Let me tell you a little story. I filed Chapter 13. And I paid what I was supposed to pay. And we sent letters out to all of my creditors. I had an attorney. And they have a certain amount of time to respond. If they don't respond in a certain amount of time, then they don't get included. But here's what I found out. Some of them deliberately don't respond. They deliberately don't respond, wait for you to finish, and then come back at you. Well, I was in a 3-year repayment, and I finished it up early. And thank God, because my attorney was, we had an agreement for a certain amount of time. Even though I finished paying off, he was still my attorney for anything that arose concerning bankruptcy until the time limit was up. So I finished, I got my great discharge letter, and I was, letting people know I had finished and everything. And here come these people sending me a demand letter. They were in my credit. So I went back to my lawyer and he said, oh, I've seen this before. I know what to do with them. So he sent them a cease and desist letter. They failed to respond in the proper time. Therefore, they forego any opportunity to come back at me. I don't know if it's still the same, because I told you this was oh man, many years ago. But yeah, you have to watch. Pay attention to the timelines, the time frames. That is going to be important. So, if you have income tax or student loan debt, you may be able to negotiate a workable repayment plan without doing bankruptcy, because it can be included, student loan debt, income tax debt, but here's what you have to file. Some student loan debt may be dischargeable by filing a separate suit called an adversary proceeding. I'm not a lawyer. This action aims to establish that repaying student loans presents an undue hardship. Under new guidance presented in 2022, just 2 years ago, many adversary proceedings have been granted. I think I'm going to try that. I just read about this now. This is from Investopedia. You cannot have income tax debt discharged without a special exemption, which can only be obtained by petitioning the bankruptcy court and explaining why you deserve relief. So, if you have income tax debt that you cannot repay, then you may be better off consulting with a tax attorney to discuss your options before filing for bankruptcy. Because if that's what you're trying to get discharged, most of the time, income tax debt is not. You can file that, but there's no guarantee. Not for income tax debt. Okay? In the case of your federal taxes, the Internal Revenue Service, the IRS, they offer several alternatives to people who are unable to pay what they owe. One is called an offer in compromise. It's in which the IRS agrees to accept a lesser amount. The IRS may also arrange for a payment plan or an installment agreement that will allow you to pay your taxes over an extended period of time. An offer in compromise. Here's something important to note. Your creditors can stop certain debts from being discharged. They may also ask the court for relief from the automatic stay that prevents them from pursuing collection activity. That's why when you're under the protection of the bankruptcy court, they can't keep harassing you, calling you, sending you letters. I've had them call me talking about, I'm calling from an attorney's office and you have 24 hours to get back. Really? Debt relief alternatives to bankruptcy. Now, I know we're talking about Chapter 13, but I owe it to you to give you this information. Bankruptcy has serious consequences. A Chapter 7 bankruptcy remains on your credit report for 10 years, while a Chapter 13 remains for 7 years. That can make it more expensive or even more impossible to borrow money if you're trying to get a mortgage down the road or a car loan or another credit card. So it might be worth exploring other types of debt relief before filing for bankruptcy, right? Debt relief typically involves negotiating with your creditors, and if you know how to write up an impassioned letter, do that. Tell people what's going on in your life, and then ask them to forgive it, or at least take it down, or stop the interest. There are all kinds of things that you can ask for. The Bible says we have not because we ask not. So debt relief often works to the creditor's advantage as well. They are likely to get more money out of the arrangement than if you were to declare bankruptcy, and I told you that before. Yeah, the bankruptcy court's going to put you on a repayment plan, but it may not be near what these people were expecting to get. You can negotiate these terms on your own, or you can hire a reputable debt relief company. It's the same. Debt relief is the same as the credit repair. But be mindful, there are scam artists out there who pose as debt relief experts. Be sure to carefully check their credentials. Research that company and do your homework. Do your homework. So, Investopedia, the site that I'm on, regularly publishes an updated list of the best debt relief companies, Investopedia. So if you're interested in maybe negotiating and trying to get your debt settled without doing bankruptcy, you might want to check this out. So let's talk about Chapter 13 and how it works. A Chapter 13 case begins by filing a petition with the bankruptcy court that serves your jurisdiction for where you live. Unless the court orders otherwise, a debtor must also file with the court these following schedules. Schedules of assets and liabilities, a schedule of your current income and expenditures, and a schedule of executory contracts and unexpired leases, and finally, a statement of financial affairs. That's something that you're going to get from an accountant. The debtor must also file a certificate of credit counseling and a copy of any debt repayment plan that's been developed through that credit counseling. You have to also provide evidence of payment from employers, if any. Again, I told you 13 typically works for people who are working. And it has to be, your monies have to be received 60 days before filing. You know, whatever you show them that you have in terms of income, it has to have been received 60 days before filing. A statement of monthly net income and any anticipated increases in income or expenses after filing, and a record of any interest the debtor has in federal or state qualified education or tuition accounts, meaning if you had applied for tuition reimbursement, or you had applied to go back to school and there was some money sitting for your books and what have you, the bankruptcy folks want to know about that. A husband and a wife may file a joint petition or individual petitions. The courts must charge a $235 case filing fee and a $75 miscellaneous administrative fee. Normally, these fees must be paid to the clerk of the court upon filing. With the court's permission, however, they can be paid in installments. I think we talked about that under an 11 or 7. It can be paid in installments. The number of installments is limited to 4, and the debtor must make the final installment no later than 120 days after filing the petition. The debtor may also pay the $75 administrative fee in installments. If a joint petition is filed, only one filing fee and one administrative fee are charged. Debtors should be aware that failure to pay these fees may result in dismissal of the case. In order to complete the official bankruptcy forms that make up the petition, the statement of financial affairs and schedules, the debtor must complete the following information: a list of all creditors and the amounts and the nature of their claim. Who do you owe? How much do you owe? And why do you owe it? The source, amount, and frequency of your income, all income. A list of all of your property, tangible property, and a detailed list of the debtor's monthly living expenses. For example, food, clothing, shelter, utilities, taxes, transportation, medicine, entertainment, you name it. You need to have a detailed list. Now, I did see some other fees. And let me tell you what they are, because in order to file a bankruptcy petition at 7 is $338. It may have gone up. So be sure to go to uscourts.gov. You can check it out there. $1,738 for a Chapter 11, $278 for a Chapter 12. I didn't talk about a Chapter 12. I'm going to have to check that out. And $313 for a Chapter 13. Let me see what a Chapter 12 is. Oh, Chapter 12 bankruptcy is a reorganization for family farmers and fishermen. Family farmers, you know, you're not farming for somebody else. You're farming for yourself, for your family. And fishermen struggling with debt in order to continue operations and avoid foreclosure, or in order to stop their business from being shut down. There's a Chapter 12. And it only became permanent in 2005. Because before that, I think they were having to file a Chapter 11, and it sort of kind of, I guess, didn't make sense. So it's a farmer and fisherman bankruptcy, Chapter 12. Well, you learn something new every day. Chapter 13 contains a special automatic stay provision that protects debtors. Unless the bankruptcy court authorizes otherwise, a creditor may not seek to collect a consumer debt from any individual who is liable along with the debtor. Oh, that's for co-debtors. So somebody that co-signed for you, they can't bother them. You're under the protection of the bankruptcy court. Individuals may use a Chapter 13 proceeding to save their home from foreclosure. The automatic stay stops the foreclosure proceedings as soon as the individual files the Chapter 13 petition. The individual may then bring the past due payment current over a reasonable period of time. Nevertheless, the debtor may still lose the home if the mortgage company completes the foreclosure sale under state law before the debtor files a petition. So there's a clock ticking here. And again, here's another sneaky little something that I didn't know. Chapter 13 is a federal protection. A mortgage company can run to your state and file foreclosure, and if they get in first, your homes could still be sold under foreclosure. You understand? It's who's on first. Between 21 and 50 days after the debtor files a Chapter 13 petition, the Chapter 13 trustee will hold a meeting of creditors. If the U.S. trustee or bankruptcy administrator schedules the meeting at a place that does not have regular U.S. trustee or bankruptcy staffing, the meeting may be held no more than 60 days after the debtor files. During this meeting, the trustee places the debtor under oath, and both the trustee and creditors may ask questions. The debtor must attend the meeting and answer questions regarding his or her financial affairs and the proposed terms of the plan. If it's a husband and a wife, they both must attend this creditor's meeting and answer questions. In order to preserve their independent judgment, bankruptcy judges are prohibited from attending this meeting. For good reason. The parties typically resolve problems with the plan either during or shortly after the creditor's meeting. Generally, the debtor can avoid problems by making sure that the petition and plan are complete and accurate, and by consulting with the trustee prior to the meeting, just to make sure. Go down a list of things and see what's what. That's why it's good to have a lawyer, of which I am not a lawyer. In a Chapter 13 case, to participate in distributions from the bankruptcy estate, because that's what it is. They take your money and they put it in this estate and they pay. Unsecured creditors must file their claims with the court within 90 days. That's what it is. And that guy that I had didn't file within 90 days. He purposely waited. Within 90 days after the first date set for the meeting of creditors. A governmental unit, however, has 180 days from the date the case is filed. And a governmental unit is the IRS, or I don't know who else you could owe that's in a governmental unit, the military or something like that. They have double the amount of time. After the meeting of creditors, the debtor, the Chapter 13 trustee, and those creditors who wish to attend will come to court for a hearing on the debtor's Chapter 13 repayment plan. Here's some notes. The current monthly income received by the debtor is a defined term in the bankruptcy code and means the average monthly income received over 6 calendar months before the commencement of the bankruptcy case, including any regular contributions to household expenses from non-debtors. Like if your children give you a stipend or give you something, that has to be included. And it also includes income from your spouse if the petition is a joint petition. But you do not have to include Social Security income or certain payments made because the debtor is the victim of certain crimes. Like that domestic violent crime compensation. There's a board, and when people are victims of violent crime, they can apply and, get some compensation for their loss. In North Carolina and Alabama, bankruptcy administrators perform similar functions that the U.S. trustee performs in the remaining 48 states. The Bankruptcy Administrator Program is administered by the Administrative Office of the United States Courts, while the U.S. Trustee Program is administered by the Department of Justice. Okay? 2 different agencies. A fee of $25 is charged for converting a case under Chapter 13 to a case under Chapter 7. And that means that if you're in Chapter 13 and the trustee or the bankruptcy administrator decides you have too many assets, or you don't have enough assets to complete a good plan, they may tell you you need to go to Chapter 7. You can eliminate that by having a bankruptcy attorney. You can eliminate all this, I didn't file the right one, I should have filed this one, I should have filed the other one. You can eliminate that. Now, I told you that it was a lot easier just to tell you what debts could not be discharged, and then you would know that the other debts typically can be discharged. I want to mention again, student loans and income tax. They never were dischargeable, but now under student loans, under something called adversary proceeding, you can seek some relief. You need to look that up. When I get ready to upload, I'll try to put some information in the comments for you. And then I'm definitely going to put that information about the federal taxes, where there is a thing that you can file with them called offer in compromise. Okay? This has been a long haul. I know. It's a lot of information. But if it helps one person, I've done my job. Like I said, I had one of our viewers in the nation had asked me to do this. I hope you're satisfied with my presentation. Bless her heart. She was really passionate about it because I didn't want to do it. Number one, I don't want anybody to say I was telling them to, file for bankruptcy. Number two, it's a lot to unpack, and I didn't want to forget anything. I did have a viewer who reminded me to tell you that student loans are not dischargeable. However, now we see that there may be a way to have them discharged under this other thing that I just told you about, which is the adversary proceeding. Well, that's it for me. I'm going to sign off now. I'm hoping this information has been helpful. I'm also asking you to check out the memberships if you're interested in viewer perks. A lot of things that I know how to do that I'm willing to share. I've been telling that young lady who asked me about helping, give her some information on publishing her book. Self-publication is pretty intense. I don't use the same programs that's currently out there, the ones that are floating around. I use an old-fashioned one, and I like them. And, the cover art, all that, it gives you more control. So if you're listening and you still want that, I told you that you could send me information on the email. Now you know 2004@gmail. You can also get the email when you're on my channel at the top of the page. Okay? Yeah. Check out the memberships. I'm getting that store together. Oh, it's coming. I also have a website that I'm working on. You don't know what you don't know. Somebody had already taken YOU don't know what YOU don't know. And so it's people out there that snatch up all these things and then charge you to get it. I didn't need it like that. So I just converted it a little bit. Instead of YOU, it's capital U. Don't know what capital U don't know .net. It's not up yet, but I'm working on it. All right? So thank you so much for listening. I pray that something here has been helpful, useful. Share, subscribe, hit the notification bell, watch the video to the end. And as usual, you don't know what you don't know. Thanks for listening.